China's another example where people think, oh, there's this contradiction. It's similar to the one that you just described for big tech, where we are both accusing them of stealing our IP, which is correct. In fact, a former director of the FBI has, I think, said that studies indicated it's upwards of something like $900 billion of stolen IP from the United States. And he referred to it as one of the greatest wealth transfers in human history, which he wasn't being bombastic. But then at the same time, they've developed their own patent system, a very strong patent system.
Hello, I'm Bruce Berman, the host of Understanding IP Matters, the critically acclaimed podcast series that provides leading innovators and experts a space to share their IP story. Learn firsthand about the strengths and weaknesses of copyrights, patents, trademarks, and trade secrets as they adapt to an AI-driven world. This is our 4th season. Adam Mossoff is one of the intellectual property's leading influencers. He is an expert in the history of IP rights and their role in innovation, and is an active participant in forming IP policy. Professor Mossoff has more than 7,000 Twitter followers, where he produces the weekly Today in Innovation History, a sometimes tongue-in-cheek remembrance of inventions past. An avid science fiction fan, he likes to unwind by riding his Ducati motorcycle. Professor Mossoff's research focuses on the history of IP rights and its role in innovation, the economy, and society. He believes IP rights are property, like other business assets, and has been a vocal opponent of government margin rights for vaccines and other patented products. His research has been relied on by the Supreme Court, the Court of Appeals for the Federal Circuit, and the federal agencies. He has been invited numerous times to testify before the Senate and the House on proposed patent legislation. His writing on intellectual property policy that has appeared in the popular press include Wall Street Journal, New York Times, Forbes, The Hill, and Politico. As professor of the Scalia School of Law at George Mason University, he teaches a wide range of IP courses. He is a senior fellow at the Hudson Institute, where he's also chair for the Forum for Intellectual Property. He and I both are members of the board of directors of the Center for IP Understanding, and it is a genuine pleasure to have Adam with us today. Welcome, Adam. You are one busy man. We finally have you.
Thank you, Bruce. And it's a real honor to be on here. And as always, it's just a pleasure to be talking with you about these important issues, and pleasure to work with you at CIP. And thank you for involving me in that incredible organization.
Thank you. When did you first become interested in IP rights, and what fascinates you about IP?
As you mentioned in your intro, I'm a geek. So I've always loved science and technology. Shows like Cosmos by Carl Sagan back in the 1970s were just inspired me and made me aware of the importance of science and technology as drivers of human life and human innovation. And then I've always had an academic bent of mind, been very interested in philosophy, and was studying it as a young person. And so for me, it was kind of a natural union of my interest in kind of government, law, theory, morality, and ethical theory, because my formal training is actually in philosophy.
That's right. You went to Columbia. I think you have a master's from Columbia in philosophy.
Yes. Actually, I was in the PhD program in Columbia. My master's is a consolation prize for leaving to go to law school. I actually did all of my qualifying examinations. I was actually doing my pre-dissertation work when I realized I didn't want to do legal philosophy. I wanted to be a law professor. Even doing legal philosophy for philosophers was too far removed from the real world. I believe in ideas. In my love for science and technology is really about, how much this matters to human life.
Most developing nations have an innovation policy. They need it because they're kind of figuring it out, a vision of the direction of the future they would like to go in. The U.S. is among the most successful and freest market economies. It doesn't have much in the way of innovation or IP policy. The country believes that the marketplace is sufficient to determine the direction of research and innovation.
Yes, well, that is an innovation policy. So we shouldn't secede to the people who think that innovation policy is not intellectual property, that, intellectual policy is, the government telling us what is innovation and where innovation should happen, right? In fact, this was one of the founders' radical insights. In addition to being innovators with respect to creating a whole entire new governmental system that had never been seen before in human history, including a written constitution that that guides the country to this very day. They recognize the importance of intellectual property, as you and I know. It's in the Constitution. It was the very first time in human history that intellectual property had been placed in a foundational document. And it was done so, because they recognized that this is part and parcel of a system of protecting the rights of life, liberty, and property. And they recognize fundamentally that intellectual property is property. Before that, it was a type of monopoly grant. It was explicitly part of domestic industrial policy in England and other countries, what we now call innovation policy, but it was really industrial domestic economic policy. And in the United States, we took a very different approach. As a matter of innovation policy, we said what will grow innovation is the same principles, the same recognition of rights as in every other area of human life, for farmers, for manufacturers, for tradespersons, for bankers. You protect rights of property, contract, you secure a free market, you provide the rule of law. Those are the key ingredients, as we know historically and theoretically, that create flourishing societies and growing innovation economies.
And we've been remarkably successful. I mean, innovation, invention, and in content creation too. Film industry, music industry. It's not necessarily an accident. In the US, rights are determined obviously by the Constitution, but also a combination of Congress and the courts. How is IP policy determined, or is it?
IP policy is determined in the same way that policy is determined in every other area, or at least historically has been determined in every other area. We've been shifting away from it slowly in the United States, by providing a set of rules, background rules, foundational rules, property rules in particular, through the 19th century and early 20th century. The policymakers in the US government viewed their job as the same job as the county recording office and recording titles. Our job is to create a system by which innovators and creators can obtain property rights. So we have to create a system by which they can obtain their title deeds and the fruits of their productive labors. And then they can use those property rights to go out into the market, like every other property right owner, like a farmer or manufacturer or tradesperson who's making, new sandals using Thomas Blanchard's lathe machine, invented in the 1830s and patented. And they can then transact with them. They can license, they can sell, they can manufacture, they can engage in all of the beautiful commercial transactions that occur when people are left free to transact with their property rights in the free market, as Adam Smith explained in his book, The Wealth of Nations, and published, interestingly enough, in 1776, the same year that we declared our independence from England.
But that rule of law that surrounds those rights seems to be diminishing. What's happened there?
Great question. And this is what I've been engaged in at the policy level for the past 10 or 15 years at least, which is, as I mentioned, the United States has been shifting away from this perspective. So it used to be that our approach was secure, reliable, and effective property rights. I mean, the protections varied and the attitudes about them varied from time to time. But at core, we know this was our contribution, and this is what the rest of the world ultimately copied from our patent systems in the 19th century. But in the past 15, 20 years, we've been moving away from this, and we've been moving more towards what you were describing earlier, a more kind of explicit top-down industrial policy type approach, where the patent system has been undermined through lobbying for new laws written by Congress, has been undermined through what we call strategic litigation. So very explicit, directed litigation, lawsuits filed and defenses argued by parties who are coordinating it to achieve certain results through the courts, and also through lobbying, and very successful lobbying of regulatory officials, especially in the antitrust agencies, the Federal Trade Commission and the Antitrust Division of the Department of Justice, to attack and undermine and eviscerate this kind of property rights foundation of our innovation economy. And so as a result, we've returned much more back to kind of this domestic industrial policy perspective of it's the job of the government to make these kind of big decisions about what prices patent owners should be charging and what type of innovation should we be investing in, things of this sort. And we've really undermined and weakened this key foundation and driver of innovation economy.
I think Scott Keefe, who is a former ITC commissioner and a professor of law at George Washington University, he said publicly that $1 billion was spent lobbying for AIA, American Invents Act, which really set back the patent system seriously about, I guess it was 12 years ago, 2012 or so. They think there is a push to support a specific agenda with regard to IP rights.
Undoubtedly, Professor Keefe, whom I know very well and respect very much, is exactly correct that there was an extensive amount of lobbying, especially by the group of companies that we now classify under the label of big tech. And one reason why they began this lobbying campaign is a lot of these companies, particularly companies like Google and other social media companies, do not have intellectual property based or at least patent based business models. Their business models are based on advertising and open and free, as much open and easy access as possible to other people's content, both copyrighted works and patented technologies. So they viewed intellectual property as a blockade to the success of their business models. It was very unfortunate. It was a very short-term perspective on their part that they took this position that patents and copyrights were a blockade to their success because actually they are a basis for their success. The founders of Google patented their search algorithm in 1999, something they don't like to talk about much, but they did, as they rightly should have, because it was a very key innovation, driver of new innovation in the innovation economy. And so they took the position, though, that these are blockades. So have spent an incredible amount of money lobbying Congress for laws like the AIA and engaging in strategic litigation and lobbying antitrust officials to restrict and eviscerate patent and copyrights.
It's hard for some people to believe, bright people, that Google and other tech companies have 40,000 U.S. patents, maybe more in some cases, and yet they don't hate patents. They just dislike strong patents that can be used against them. So it's kind of a weird dynamic that they have so many patents and IP rights and trademarks, but at the same time, they're dubious about them.
I disagree with that because it's actually consistent. They make an argument about why it's consistent, and their argument makes sense, which is because they don't use patents. They don't assert them. Google doesn't sue people for patent infringement. They don't make money from patent licensing. So their argument is, well, of course we have to acquire patents because we have to defend ourselves. So, this is Elon Musk's argument that, patents are for the weak, as he likes to say, because this is just what you do because you don't really use them to produce value. You use them to protect yourself against all these horrible people who are trying to attack you with their patents. And so it's not really true to say they like patents by evidence of the fact that they get them. You have to look at the fact of how they're using their patents. And this is what they say when they go to Congress. This is why they've been so effective and successful. So it's not true that they're being inconsistent. The point is that what's not true is just because they don't use patents in their business model doesn't mean that patents don't serve important foundational fundamental role in other people's business. And more importantly, they are stealing people's technologies, as we have recognized and as the American public has learned through such lawsuits as Sonos with their fight with Google. They engage in this practice predatory infringement. So the weakening and elimination of patents and copyrights for them is because they want easy access to these products and services by both the people who use their services, but also by them themselves. So they engage in a practice of what's now called predatory infringement, where they just steal things because it's easier and cheaper for them to do so, because they've weakened the patent system and the copyright system in doing that. They don't like patents, and both their business model and their acquisition of patents and their policy arguments are all consistent on those grounds.
Adam, China is a challenge for the U.S. IP rights and innovation. It's a challenge in other ways as well. It receives significant capital from the government, unlike, we provide capital too in some cases, such as semiconductors, but it's a bit different. It's been active in IP filing and courts, but rule of law is highly inconsistent and applied inconsistently, especially for foreigners. As China becomes more IP conscious, it seems that U.S. IP rights have become weaker and more uncertain. How do we get here and how do we fix this?
China's another example where people think, there's this contradiction. It's similar to the one that you just described for big tech, where we are both accusing them of stealing our IP, which is correct. In fact, a former director of the FBI has, I think, said that studies indicated it's upwards of something like $900 billion over the time of stolen IP from the United States. And he referred to it as one of the greatest wealth transfers in human history, which he wasn't being bombastic. But then at the same time, they've developed their own patent system, very strong patent system.
And it looks very good on paper. They say all the right things.
Well, it looks good on paper because they copied our patent system from about 30 years ago. So it's like they're not only copying our inventions, they're copying our patent system, which seems to be like a contradiction. It's like, well, which is it? Well, it is both. because for China, it's domestic industrial policy. So they have succeeded very well over the past 50 or 60 years stealing technology from the West to grow their own economy. But they also recognize they can't keep stealing technology. At some point, they have to then grow their own innovation economy if they are eventually going to displace us and become a geopolitical powerhouse in the world, which is what they're seeking to be. And so they've created then a structure to promote and foster their own innovation economy internally. And so it's very much of a piece. It's all about growing their own domestic economy through theft of innovation from other countries and promoting their own citizens to innovate and invent and deploy technologies. And so they have done this by both copying our technologies and our creative works and by copying our patent system. They don't have the rule of law. Companies like Huawei, we call them companies, but they're not companies in the way that we think. I mean, if Xi calls up the president of Huawei and says, "You're going to do this," Xi says, or the president of Huawei says, "Thank you, sir. Yes, I'm going to do that." That doesn't happen in the United States, or at least ideally it shouldn't. They've created this system, but it serves their own domestic industrial policy purposes, their own domestic industrial policies. So they're deploying their courts in ways that are not following the rule of law. They favor their own companies. For instance, in disputes with innovators in the telecommunications sector, which all come from Europe and the United States, we're talking about Qualcomm, Ericsson, Nokia. I mean, all of the primary innovators are still European and the United States-based innovators, right? So and they are licensing their technologies to the mobile phone manufacturers, HTC, Huawei, others. So of course, then they're using their courts to artificially depress licensing rates because they want to pay less, because for them that's a cost. That's money going out of their country as opposed to staying in their country. And so I think we need to recognize this in two ways. We need to both address the improper abuse and exploitation of their courts, which doesn't appear to be abuse and exploitation unless you know that this is what's happening, because it's just courts issuing decisions. So if you don't really know what's going on in the background, then it looks like it's normal processes, and it's not. So we need to address that at an international level. So, for instance, there's a complaint filed at the World Trade Organization by the EU in the United States on this exact issue, arguing that China is unfairly and improperly exploiting its courts and its other government agencies in favor of its own citizens in ways that violate treaties and other requirements under international law. So we needed to be doing that, but we also need to recognize and address this more foundational problem that we've done, which in our own country, which is we've undermined and eviscerated our IP system. We weaken copyrights, we weaken patents.
At a time when they probably should be stronger than ever, not weaker.
Yeah, it was all of the times where we've had reliable and effective property rights were the times that we drove the radical revolutions in innovation that have fundamentally altered our lives, from the computer revolution to the biotech revolution. This is one of the things that I always point out when I chat with people about the patent system, and they say, "Well, what about patent trolls and all the excessive, patent protections? Isn't that stifling innovation?" I was like, actually, it's the exact opposite. The people who make those arguments, the problem is that historically, if what they were saying was true, then we wouldn't have had the biotech revolution. We wouldn't have had the computer revolution. We wouldn't have had the mobile revolution, because all of the things that they're saying about the patent system having been out of whack occurred at exactly the times where we drove those incredible technological and economic revolutions.
The U.S. still outspends China by about $100 billion a year, which isn't that much more, maybe by 10, 15% on R&D. Do we need to continue to spend on R&D and outspend China? Would that make us more competitive?
I don't think that that's the right question to ask, because I think the more important question to ask is the R&D being spent in appropriate, correct ways? Is this R&D that's being invested by innovators and creators, or is this government picking winners and losers in the marketplace, which is what we're starting to do? And that is not the recipe for success. That's not what happened when the biotech revolution occurred, when the computer revolution occurred. Those revolutions occurred because individuals like Steve Jobs, Bill Gates, and just yesterday was the anniversary of Jack Kilby in 1958, demonstrating for the very first time to his colleagues at Texas Instruments his invention of the integrated circuit. the what we now call the microchip or the chip, which is the silicon-based chip that combines a transistor, a resistor, and a capacitor all in one thing. And and he gets a patent for it in 1959. This is the foundation for the entire computer revolution as we now know it today. I mean, this is what leads to pocket calculators, which was the very first application of it in consumer products in 1971. But then, of course, the personal computer revolution, the mobile revolution, everything. And it's now chips are in every products, our cars, our refrigerators. And that was done because he was at a private company. He was a private individual. In fact, he had a hard time convincing his colleagues about his invention. It's a great story of kind of unpredictable innovation, even when the company doesn't even know necessarily that this is a great innovation. Since he was new at the company, he hadn't built up his vacation time yet. So all of his colleagues in the R&D department went on vacation, and he had a week of just being alone in the company. So he took that week to build his microchip, his prototype. So when they came back, he said, "Here, this is what I've been talking about," and he demonstrated it to them, right? So, and this is like a great example of like how even the people at Texas Instruments didn't understand what he was explaining to them because it was so radical. And if companies which have financial incentives in these matters. I mean, Texas Instruments made billions and billions of dollars on this. Certainly, a government official is not going to be knowing like what's next, what's the next great innovation 10, 20, 30 years down the road. And so, we just witnessed this yesterday with SpaceX, with the very first private spacewalk, by humans, by the way, who are currently right now farther from planet Earth than any humans have been in 50 years. 50 years. And why is that? Well, because we decided to go through the government. Now, the government did incredible things. NASA did amazing things in the 60s, put us on the moon. But then notice, we really haven't done much since then. When we talk about R&D, I mean, it's very important. Yes, we want to have lots of R&D. But if it's government dictating, well, this is the R&D we're spending, I don't think you're going to see the type of technological revolutions and the technological innovations that we have seen in this country from the Industrial Revolution up to today's mobile revolution.
They're not in a position to judge those sort of developments. The Biden administration, Adam, has threatened to assert margin rights on products protected under U.S. patents, under the premise that they're too important for a single business or individual to own. What's the weakness of this logic?
Oh, well, there's several.
I was going to say my original question had weaknesses, and then I cut it back, but I should have kept weaknesses.
Yeah, exactly. There's multiple levels of problems with the argument. The first and most obvious is the laws don't actually allow the government to impose price controls.
But isn't there some clause, a marching clause with government research? They can, with regard to patent, they can come in.
Yes, but they can't do it for the purposes of lowering prices. The clause is the whole point. So the Bayh-Dole Act, which is what we mentioned earlier in 1980, was enacted for the purposes of ensuring that research that may have been contributed to by public funding, so very far upstream research at universities, basic research, foundational research by professors gets ultimately deployed in the marketplace. So all that Bayh-Dole said was, because there was some confusion about this, it doesn't matter if the 1 cent of federal funding was contributed at some point in the 10 or 15-year R&D development process. If you invented it, you can get a patent. So the Bayh-Dole was simply a codification and a reaffirmation of the foundational principle the United States established in 1790. If you're an inventor, you can get a patent and you can deploy that patent in the marketplace, meaning which we call licensing. They recognize that, well, what happens if someone gets a patent but then they don't deploy in the marketplace? They're just sitting on it, literally sitting on it. And that was the whole problem that the Bayh-Dole Act was meant to address, because there was uncertainty about all these innovations in the 60s and 70s, especially medical care innovations, where the NIH had funded something or some government agency had provided some funding, and people didn't know, well, can I get a patent on this? Can I not get a patent on it? So it was, in the law, we call this a cloud on the title. And so these inventions were sitting there on the shelf, metaphorically, being unused. And if the whole point of the Bayh-Dole Act was to get things into the marketplace, well, saying to someone you can get a patent, but then you get to sit on it and not deploy in the marketplace violates the very point of having the Bayh-Dole Act. So they created this notion of what's called a marching power, which is that, okay, if you get a patent, but then you're sitting there doing nothing with it, it's not being deployed in the marketplace, or you license someone to deploy it, but they're not doing anything, then the government has the right to license someone else to deploy it into the marketplace. So the whole point is to get products out of the lab into the marketplace, which was the whole function and purpose of the Bayh-Dole Act. The US government knows how to enact price control laws. When it's concerned about prices, it enacts laws that impose what are called reasonable price or fair market price conditions. That's not in the Bayh-Dole Act. So it's not even in the language of the statute. So it's a huge convoluted legal argument about why people are trying to manipulate, twist, and warp this law into a law that serves this policy goal of reducing prices of drugs and other types of patent products and services in the marketplace. So, as a preliminary matter, what they're arguing is not authorized by the law. And so, I mean, that should end it. But it's also just a bad policy. Price controls are no different than the government picking winners and losers in basic R&D. In fact, economists widely recognize that price controls are incredibly destructive of markets. I mean, and rent control is an example of this.
You create something that's so good, could be a graphical user interface or something. It seems ubiquitous. This is too good for anyone to own. And then you're rewarded with taking it away, like the COVID vaccine. It's wonderful. In 9 months, they created this remarkable thing. And it seems like this should be in everyone's hands. It should be free. But someone created it and invested billions of dollars to help get it out there. And this is true also in content. People just feel it's too good for someone to have. We all have to have this.
Exactly. I mean, the idea that, the moment something becomes successful and people need something, that becomes the basis for then taking it away from the person who owns it, is the moment that you lose all notions of protection of individual rights, property rights.
Right. Then why bother? Like someone said that it's a sugar high. You're giving away good stuff to everyone, but eventually investors are going to back off and say, well, wait a minute, if we do great here, really super great, we're going to lose it. We may lose control over it. It's not democracy.
Right. I mean, that's one argument, right? That's kind of the classic, people won't be incentivized to create new products and services and things of this sort. I mean, but there's a more foundational argument to it, right? The founders didn't create our government because they were like, oh, well, we want to just incentivize people. We just care about incentives. That's not the only argument. And it shouldn't be the only argument, because they're arguing incentives too. They're saying, well, people need to be incentivized to live. And if people can't live, if people don't have food and housing and drugs, then and then it just becomes an argument over incentives and who has the bigger incentives. There's a more kind of fundamental point here, which is the protection of rights foundationally and fundamentally that we created in this country, which we talked about earlier as the key ingredient of the success of our country, was not about dangling cheese in front of producers and manufacturers as mice to incentivize them. It was recognizing that the fundamental protection of the rights of life, liberty, and property are key to a just society. It's a matter of justice. It's not just a matter of incentives. That it's unjust and wrong to take from people what is legitimately and rightly theirs, especially if they've created it. The Declaration of Independence doesn't say, we want to incentivize a better society, and therefore this is why we're breaking from England. It's like, no, it's unalienable rights to life, liberty, and property. And this is my point earlier too. It was a key insight of our founders to recognize that patents were part of that moral principle that they were invoking. This isn't economic policy, why we have patents and copyrights. This is part of the moral claim that one has to one's life, one's liberty, one's property. And property includes your intellectual property.
There's a wonderful painting that hangs in a National Portrait Gallery, Men of Progress. It depicts the history of invention. I think it's circa 1862. And it's, James Watt and all those guys. And the portrait of Benjamin Franklin hangs on the wall, the father of invention. That was kind of photoshopped. They did a bunch of different portraits and they put them together. And each person, all men, and they're looking in different directions. Ironically, that building, that National Portrait Gallery, was the patent office. I think it was completed in 1837. It's a wonderful building. Is that vision accurate as of 1862? Was that where the country was with regard to innovation and invention?
Yes, that portrait kind of captures beautifully how significant and revolutionary the United States had been. That we've lost this in a certain sense, given just the passage of time. When we broke from England with the Declaration of Independence in 1776, and then the Treaty of Paris in 1783, England really did feel like, we were like an upstart little teenager. We all have teenagers who think they know everything, right? That song in Hamilton, "You'll Be Back," from the crowd. That was serious. That it's a great song. It's really funny, but it's also that was really the belief at the time that like, yeah, they're gonna figure it out that they can't do this. And there was some basis for thinking that because we were, at that point highly indebted. We had a, mostly agrarian economy. We had just come out of massive war. We were fighting amongst each other under the Articles of Confederation. If you were a betting person, the United States was not the country to bet on. And yet, at the very first World's Fair in 1851, the Crystal Palace Exposition in London, we are marveling the world with all of the innovations represented by the inventors in that portrait. So Samuel Morse's telegraph, Charles Goodyear's rubber, vulcanized rubber, Blanchard's lathe machine. There's sewing machines, a Samuel Colt's repeating firearm, Cyrus McCormick's mechanized reaper, and so on and so on. And people were just utterly shocked by this. And by the way, this is one of the reasons why our patent system starts to get copied because people are like, how did this happen? And where did all this innovation come from? From a country 60 years ago that was almost entirely agrarian, massively in debt, was dependent upon, foreign countries for support like France and others for our defense. So like, and the answer was our patent system. And not just our patent system embedded within a system of rule of law, stable political legal institutions and things of that sort, but the patent system as a property rights system, as a system that recognized that you create it, you have a right. In fact, this was a very common phrase used at the time for patent owners, that you have a right to the fruits of your productive labors or the fruits of your labors. And just like a farmer does when they grow crops, or a tradesperson when they makes a tool, you're an inventor and you have a right to value this new valuable asset that you've created in the world and its invention. And we're going to protect it as a property right. That painting captures perfectly kind of the revolutionary sense in which the United States was the first country that becomes largely created through innovation. The innovation made possible by the property rights protections of the patent system.
One wonders what a similar depiction would look like today. It would be far different. Aside from invention and innovation, which we're still very good at, it'd be a lot of packagers, like companies that are able to take the inventions of others and make them.
No, I think it would. I disagree. I disagree with that. I think that it would still be great innovators. It would be people like Jack Kilby, who I just talked about, and Bob Noyce, who also independently invented the chip at Fairchild Semiconductor a couple months later. It would be people like Dr. Chakrabarty, responsible for the biotech revolution. It would be people like the founder of Qualcomm, Dr. Irwin Jacobs, the creator of what we now call 4G, 5G, 3G, the creator of the digital telecommunications technology. They're all patent owners. These are all patent owners who deployed their patents through manufacturing and more importantly through licensing. And they're like, well, we want to make a business. We want to make money. And Bill Gates, who wrote an open letter to what was then called the hobbyist community, and we would now call hackers, in the 1970s, saying, if you keep stealing computer code, we will never create an industry. We will never have our computer revolution, which was it was a heroic letter that he wrote. And so these are the people you would have the same painting with the same incredible innovators.
Adam, there have been 8 related patent bills in Congress in the past 5 years, intended mostly to restore the system and an attempt to level the playing field once again. Currently, there are 3 important ones. They're bipartisan, PARA, Prevail, and Restore. Can you quickly summarize the importance of these bills and their chances for success?
Those are the 3 big ones, really important ones. So PARA, and these are all acronyms, which because Congress only knows how to pass laws now that go by acronyms. So PARA addresses a very technical issue in patent law about what count as eligible inventions, because you can't patent abstract ideas and basic facts in the world and things of this sort. And this has been an area where the Supreme Court issued 4 opinions that really were destructive to the patent system, narrowing and restricting the scope of what counts as even eligible inventions that can be patented, especially in the biotech and high-tech space, are 2 areas where are the sectors of our innovation economy that are driving our economic growth and have created a lot of uncertainty. And so these four court decisions, I refer to them sometimes as the four horsemen of the innovation apocalypse, have really undermined and destabilized the patent system as this driver of this engine that has driven the U.S. innovation economy. So Paro basically, reverses those decisions because Supreme Court decisions in this area are not constitutional decisions; they're interpretations of the laws that have been enacted by Congress. And so Congress can say, "You got it wrong, court." In fact, Congress has done that a lot over the past 200 years or so, has stepped in and said, Supreme Court got it wrong. We are changing the law. And in fact, they did that in 1952 in a lot of really significant respects, which is the last time a massive patent bill was passed. That was a good bill, in addition to the Bayh-Dole Act, 1980. Prevail addresses this new agency that was created by the American Invents Act that Professor Keefe and others have probably talked about on your show already. This agency at the Patent Office called the PTAB, Patent Trial and Appeal Board, that sole job is to cancel patents, to basically, say the Patent Office shouldn't have issued this patent. It's a bad patent, as the term is used. I don't like that term because it makes it sound like, patents from the wrong side of the tracks with leather jackets and earrings or something. The problem is that when Congress created this agency, it did so through the lobbying of big tech, which are the primary filers at the PTAB now, as evidence that they really wanted this. And so they put almost no procedural or substantive safeguards into the agency as how it would function. They basically created an agency, six statutory provisions govern the entire operations of this agency, which tells you how little guidance it got from Congress. And they told it, here, you need to cancel patents and you need to do so fast and efficiently. Well, as we all know, the classic, aphorism, you can do something fast or you can do something right, but you can't have it both ways. The cancellation rate in some of the programs at the PTAB have been as high as 100%. There's no organization, institution that functions at 100% perfection, especially canceling patents. In other programs, it's, as low as 83%. So you've really got an institution out of whack here, and Prevail would impose very important procedural and substantive safeguards on patent owners as owners of property rights appearing before this agency, and would bring back the rule of law to the operation of this agency. Ideally, this agency shouldn't exist. Patents that were mistakenly issued by the Patent Office, because people do make mistakes, from 1790 until today, in fact, still to this very day, you can challenge them in court and go through court processes, which is what anyone should do and is required to do in all other contexts with a property right that has been secured to you under either statute or court decision.
The irony too, Adam, is that if you make it through the PTAB, which is difficult increasingly, and all of your claims or the remaining claims are upheld, you would think, well, this is perfect for licensing now. You have a gold-plated patent. It's been through the patent office. It's been through the PTAB. So I could just license it. Well, no, that's not the case. Now you start litigation after being through.
Yeah. Or they refile more PTAB petitions against you. I mean, there are some patent owners who've had 40 petitions filed against them, one right after the other, by big tech companies because they tie up the patent in litigation and imposing all the costs on them. Meanwhile, the lawsuit itself, as you just mentioned, is sitting there waiting for all of these petitions to be resolved.
What bothers me personally, and I'm sure others, from a shareholder point of view, I could sort of understand what some tech companies are doing because they're maximizing profit, efficiently infringing, et cetera. But what does this do to the DNA of innovation? When a handful of companies are determining what's innovative, and what's innovative is what they can control or profit from.
But that's why, I don't like that term, efficient infringement, because it's not efficient, because they're destroying the patent system. And by destroying the patent system, they're destroying innovation and the ability of our economy to succeed, and the ability of themselves at some point to succeed, because many companies that don't have business models that today rely on patents end up relying on patents more later, and vice versa. I mean, and so it's short-sighted. So, people talk about, oh, Wall Street's so focused on the next quarter and how irrational that is. That same irrationality is evident here in this practice, which is why I call it, and the better term for it is predatory infringement. So they're actually stealing inventions and they're using and exploiting these agencies that they helped create through their own lobbying efforts to steal inventions. And for the same reason that theft is not really efficient, even though it may momentarily benefit someone in the short term.
It's efficient for shareholder value,
But
perhaps.
it's not even efficient over the long run for shareholder value. It's only in the short term. It's the short-term perspective. It's the same short-term perspective of the thief who says, "Oh, there's a bicycle there. I'm going to steal it." You think, okay, well, does he now have an access to a resource he didn't have before? So is it he increased his efficiency? Yes, but that's not the right sense of efficiency. And no economist, I think, would properly recognize that. And so we shouldn't call this efficiency. We shouldn't say it's even it serves their shareholder value because it doesn't over the long run. It's that same, just because you benefit today, you have to ask though, yes, but is this something that makes sense and is rational, not today, but tomorrow and the next week? And because we are humans who live not just today, but we live 60, 70, 80 years, and companies and societies hopefully live for centuries. And to come back to the third bill that you mentioned, which is to me the most important one of all, the Restore Act. It's one sentence, which is an incredible bill for Congress to do. And if it again addresses a foundational, fundamentally mistaken Supreme Court decision on the ability of patent owners to stop predatory infringement. So it's good that that can now talk about this bill now that we've talked about the issues from the Prevail and Para, the PTAB and patent eligibility. So, there's all this predatory infringement. Well, one of the reasons why predatory infringement is occurring is not just because of the PTAB, it was because the Supreme Court in a decision in 2006 made it much harder, almost next to impossible for many firms to obtain injunctions. An injunction is that court order that stops someone from using your property without your permission. The way I frame this to people is, imagine someone comes and starts living in your bedroom. And, so you come home from work and there's someone in your bedroom. When you call the police, that's an injunction. You're getting them removed from stopping from infringing your property rights. Now, imagine if you couldn't do that. If the police said, well, sorry, you have to sue them, and you go through 5 years of litigation. Meanwhile, they're still living in your bedroom during those 5 years. And the judge says, you still can't kick them out. We're just going to require them to pay rent. And by the way, I'm a judge and I'm going to tell you what the rent is, which is now we're in rent control. We're in a government official telling you what the value of your product is and the value of your home is, right? And now imagine you trying to sell your house during those 5 years in which you're in litigation, trying to get this guy out of your bedroom, or even imagine trying to sell your house after you get the court decision. You're like, yeah, so you can buy my house, but there's a guy living in the bedroom who's paying rent, and I can't kick him out because the judge has said he can stay there, and as long as he's paying rent. By the way, rent that the judge decided what I should be paid for.
It's a great analogy. It's really a good illustration.
It's exactly what's happening to patent owners right now. So this bill reverses, the legal term is abrogates the Supreme Court decision and restores the rule the patent owners had, which was the same rule that homeowners have, that other property owners have, going back to 1790.
This is a bipartisan bill, and it's both in the Senate and the House currently.
All the bills are. All the bills are bipartisan, and all of them are in the House and in the Senate. So it shows you that there's significant concern about our patent system right now, that we have three indisputably important patent reform bills that address these foundational fundamental weaknesses that have been created in our patent system in the past 15 to 20 years.
Adam, we're running short on time. I'd like to ask you a final question, and it relates to something that we've been working on, you and I, a little bit. It's been announced that for 24-25, the National High School Student Debate will address the pros and cons of strengthening U.S. IP laws. It's timely to bring the IP discussion to students. How do you think they should prepare? Everyone's going to go to Google and sort of like look up, what are patents and, who should own them and how they should be used. But I don't know what might be a good way to go.
This is very different when I was doing debate back in the 1980s because we didn't have Google back then. We didn't even have the internet yet. Well, the reason why it's an interesting question is kind of a somewhat hard question to answer is because of all of this kind of, we've talked about already, the lobbying and everything, there's a lot of false narratives. There's a lot of rhetoric, what I call rhetoric, as opposed to kind of fact-based, rigorous analysis and discussions about the patent system. So there's a lot of like labels and name calling. I've mentioned one of those phrases already, patent troll, and there's many others. And the problem is that a lot of academics use these terms. It's unfortunate, but they do. So if you you find a law journal article or even, an article even in another type of peer review journal, you can't necessarily assume that that actually is an article that, is presenting fact-based, evidence-based analyses of the patent system and how it functions. In fact, much of my start of my academic career was spent responding to and calling out a lot of myths about the patent system. For instance, a lot of scholars say, oh, patents were always monopolies. They were never property rights. And so one of the reasons why I know what I know now is because I said, those are really interesting claims. I actually went and reread all the patent decisions of the 19th century and read all the treatises from the 18th century to find out if that was true or not. And I discovered it wasn't. And that's how I've been able to work as an academic, where I've been now pointing out errors and mistakes in people's arguments. So my recommendation to the high schoolers who are engaging in this debate or engaging in this topic, which is fantastic, because I did high school debate and I would have loved to have had this topic in the 1980s, is to be a critical reader, to be very rigorous in your own thinking about, well, does this make sense to me or not? Is this an argument that is fact-based and is making a valid point, or does this sound like it's policy arguments, it's rhetoric, it's, and things of that sort. It's agenda driven, right? Or as we would say in DC, sometimes policy driven, like the results oriented, as opposed to trying to really understand what's happening in the patent system. Because it can be hard to differentiate those issues sometimes. And so just to be kind of critical readers of the scholarship and of kind of public writings on the patent system more generally, because you have the same problems in copyright and trademark and trade secrets as you do in patents. Yeah.
Adam, this has been wonderful. We went over time a little, but that's okay. I have to have you back on again. This is the beginning of the conversation, but it's great to have you, and thank you. Understanding IP Matters is brought to you by the nonprofit Center for Intellectual Property Understanding, with the generous support of its partners and sponsors. Gain access to all 4 seasons by subscribing for free on your favorite platform, or email us at explore.understandingip.org. Content conveyed is for informational purposes only and does not represent the views of CIPU or its affiliates. This episode was produced by Jack Shields for Wild Creek Studios. Thank you for listening.